are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday at 10 a.m. Pacific time to talk about estate planning and probate and trust administration, primarily from the standpoint of professionals like myself who do this for a living, but also for you if you are going through an estate planning process or have questions about it, may need to update it, and just in general want to make sure that your finances are handled properly. So today I'm going to talk about a subject that comes up, unfortunately, far more often than those of us who are professionals would wish it does, I guess is the best way to put it. And it's the issue of a contested intestate succession. So I can tell you that outside of the trusts with which I deal, the probates I handle tend to be in that category. I think that's one of the reasons why that a professional fiduciary ends up administrating these estates, and this is the absolute best argument I can make in favor of the necessity for people to have estate plans. And I'm going to go through 6 of the most common problems that arise when someone dies intestate, and the 6 most common contested issues. And I'm going to give you some examples from my practice without naming names or citing case numbers, although what I'm going to talk about is a matter of public record, which is, of course, I'm not going to talk about this as one of the 6 points, but when there's a contested intestate probate, all of the dirty laundry inevitably gets aired in court. It's in the public record now, and it's just ugly. There's no other way to describe it. So I'm gonna kind of get right into this, and like I said, I'm gonna use some examples from my own practice so you can see how some of these things play out. Okay, so just to be clear, we're talking about a situation where somebody died. They did not have a will, they did not have a trust, and so now their estate is going to be administrated according to the laws of intestate succession for the particular state in which they lived, were a resident. Really, they could have died somewhere else, but that doesn't mean, just because they didn't die in the state of their residence doesn't mean that their estate will be probated there. It's almost for sure going to be probated in the state in which they lived. Okay, so you can look at driver's license, voting records, whatever. That's probably where the person's estate will be probated. Okay, so now assuming that the person has heirs, this is oftentimes where the contests come from, in the sense that if the decedent has only one heir, then there's really nothing to contest. Okay, because it's just that one person's going to get everything. Okay, and so they're most likely not going to argue with themselves. Okay, however, the mere fact that somebody died intestate leaves open the question of who is a valid heir. Okay, and so determining the heirs becomes the first issue. Okay, so without a will, okay, that specifies these people are my heirs, these other people are not my heirs. Okay, virtually anyone can walk into court not literally walk into court, but they can file documents claiming to be an heir. Okay. Now, the reason that's a problem is because the resources of the estate are going to be, will have to be spent determining whether in fact this person is a valid heir or not. Okay. And if you've got a, even if you've got a pretty clear situation. So I'm administrating an estate where a man died. He had one child. That child is his sole heir. He was not married at the time that he died. He had been married previously. He and his wife were divorced for a long, long time. He never got remarried. Okay. Again, had one child. Very clear, according to the laws of descent and distribution in California, that his one child is his sole legal heir. Okay. Notwithstanding that, at one of the hearings where I was being appointed as what's called a special administrator, okay, someone showed up and objected to my appointment because this person claimed that she was an heir. Okay, she claimed to be like a cousin or a second cousin or something like that. Okay, and the court, not knowing any different, continued the hearing on having me appointed as the special administrator pending resolution of the status of this woman. Okay, now I had covered all of this with my attorney and the other people involved. This woman, there were no cousins, okay, anywhere in the family. And second cousins are not close enough to be included as an heir in an intestate succession. Okay. So this was clearly just this woman trying to essentially extort money out of the estate. Okay. Nonetheless, okay, my attorney had to contact her attorney and, explain to him, how this was going to work. And when the attorney saw that we were not going to cave in and just give her money to go away, he withdrew because he realized here was a woman. She had no money of her own to pay him, right? And the estate was not going to pay her a dime. I made it clear. I'll spend $100,000 fighting her. I won't give her 2 cents to make her go away. That's essentially what I told the lawyer. Okay, because I had been nominated by the legal heir, right? Why should I agree to give away his money to a complete fraud? Okay, nonetheless, okay, the attorney gets paid. Okay, now there was a delay in beginning the administration of the estate because the hearing got put off for I think about a month and a half. Okay, there were people who were angry about that, who were clients of the decedent. Big mess. Okay. And so I have another case that I'm handling where there are, again, it's a man died intestate. Okay. And he left behind actually quite a number of heirs. Okay. I think 10 in all. However, one of the heirs, the decedent's sister, tried to exclude 2 of the legal heirs. Okay, they were another brother and sister of theirs. Okay, but they were older. One of them was not mentally competent, so he didn't really know what was going on. Okay, and then there was another heir, what would have been an 11th heir, who claimed he was the spouse of the decedent, but there was no record of any marriage. There was no record of any registered domestic partnership. Okay. Nonetheless, this went on for 7 months. And the issue of the brother and sister of the decedent still hasn't been resolved. Only the issue of the potential husband has been resolved at this point. Okay. And in the meantime, like I said, 7 months went by. during that time, the administration of the estate could have been begun. And in fact, most of the work, well, not most of the work, but probably at least half of the work could have been done, and the heirs would have been halfway to getting their inheritance. But instead, we're now, I just got appointed a couple of weeks ago. We're now at the very beginning of this whole process. And there's still the issue of whether these two other people are legal heirs to be decided by the court. Okay. So, and as a result of this fight, there is a lot of bad feeling between kind of the two sides. The ones who are working to make sure that every legal heir is, being included in the estate, and the other one that's saying, in fact, this side is trying to include people who are not legal heirs. Right now, as the administrator, it is not my job to say you're a legal heir, you're not a legal heir. It's my job to identify who are the legal heirs, right? So I'll attend the hearings on this issue, and whatever the judge decides, that's what it's going to be, okay? My point of bringing up determination of heirs as the first issue in a contested intestate succession is it takes a lot more time to deal with than if there was a will or a trust that specified who's going to inherit. Okay, takes more money. Okay, sometimes these matters are not within the normal scope of the administrator and the lawyer representing the administrator, and so it could lead to their being able to claim extraordinary fees, which is an added cost to the estate. Okay. And in the meantime, often when people know that they're going to be getting money from an estate, so there are companies that will advance them that money. Okay. But they don't do it for free. And so if an heir takes an advance, that means in the end, they're going to get less money. And when these kind of delays come up, heirs are really more often they decide to go ahead and take the advance, even though in the end it means less money because they want the money, they need the money, whatever it is. Okay, and so they end up getting a smaller inheritance as a result of what they see as being these long delays, and they are oftentimes long delays. But what they see is, this fighting is going to go on. We never know who's going to win, et cetera, et cetera, et cetera. Okay. So, and aside from the time, the extra expense, the wear and tear it takes on relationships is of course lifelong. Okay. Rarely are these breaches ever fully resolved down the road. Now that the decedent is gone, oftentimes it is the decedent who kept these relationships together while he was alive. And once that person is gone, oftentimes that's it. The glue that held everything together is gone, and every slight, every jealousy comes to the fore and is played out now, and it just explodes into a hot, if not a cold war, basically. Okay, so determination of heirs can be very difficult, right? Birth certificates, witness testimony, all of these things may be required. So a lot of other people are going to get involved in the probate now. And again, a lot of bad feelings. Okay, so that's number one. Number two, petition. There may be competing petitions for someone to be the administrator of the estate. Okay, and oftentimes that's where disputes between the heirs starts. Is you have an estate, there's more than one heir, there's already some distrust between the heirs, and so both of them file petitions for administration. okay, and they start making accusations against the other. Well, this one's incompetent, this one's going to steal, this one's going to do this one's going to do that, okay? And now it all ends up in the lap of the judge, right? And it's up to the judge to figure out what to do, right? And as I mentioned in the beginning, this is oftentimes where all get involved is someone will come, a case will be embattled, and the two sides can't come to an agreement as to who the administrator should be. And so the judge will recommend, well, why don't you just hire a professional? That person has to be neutral. That person has to be bonded. And that way we can proceed, because this fighting, it's never going to get us, it's never going to get you anywhere. Okay. So again, another situation where I've been asked to potentially be the administrator. So a man died. He left behind his second wife, to whom he's been married for over 2 decades at this point. Okay. And he left behind 2 children from his first marriage who are now, grown up people in their 20s, at least in their 20s. And now, in California, the wife of a decedent has priority in appointing an administrator. And so that's what the wife did. And the stepchildren, basically her stepchildren, turned around and said, she's not an heir. She's stealing money. She's doing all these horrible things. And so they nominated one of them to be the administrator. Okay. And now, the dispute has heated up to the point where I've been asked to come in and, hopefully be appointed and then, straighten all of this out. And by the way, in this particular case, the stepchild who is petitioning to be the administrator, accused the second wife of having stolen and sold certain assets. Okay. Meanwhile, those assets I don't want to say what they are, but they're in the backyard of the house in which the decedent lived. Okay. But of course, the court doesn't know this. The court doesn't go visit, a residence or see right. And so, the court only knows that, one side is accusing the other of dishonesty and theft, and the other side is basically sitting in court crying because her husband died just a few months ago, and she's, her husband of like I said, over 2 decades, is gone, and she wants to mourn, and in the meantime, all of this, turmoil is going on. Okay, so another thing that a will does, is it appoints an executor, and oftentimes it will appoint a successor executor in case the first one either predeceases the decedent or doesn't want to serve or something like that. Okay, so it makes it clear who's going to be the personal representative of the estate. And same with a trust. A trust appoints a trustee or a successor trustee, sometimes multiple layers of successor trustees. So there's no question about who is going to be handling the administration. Okay. Without a will or a trust, now it's up to the court to appoint somebody, and hence where the dispute comes from. Okay, let's take a sponsor break. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. call us today at 213-264-4396 or visit magnumprops.com. So this is Trust and Estates Weekly, and I'm your host, Kevin Bemmel. I'm talking about contested intestate probates, okay? And the most common issues that arise, how that relates to the intestate situation. And I mean, I'd like to give you some solutions to them, but unfortunately, these situations often take on kind of a life of their own, and until the parties are exhausted, either financially or emotionally, they tend to go on and on, or until they frustrate the court to the point where the court just, the judge just sort of lays down the law. So I talked about determining who the lawful heirs are. That's a prime area of dispute. Another prime area of dispute is who will be appointed to administrate the estate. Okay, another area ripe for dissension that, if there had been a will or a trust, wouldn't be an issue. Okay, so next are creditor claims and debts. So one of the things the estate must do before the probate closes is it has to pay valid debts. Okay, so before the heirs get any money, okay, all the valid debts of the estate have to be paid. And there's a process by which creditors submit their claims to the probate court and establish that this is in fact a valid debt. Okay. Now, what happens in an intestate succession is, because there's a lot of turmoil going on, creditors are not notified, or potential creditors are not notified in a timely way or timely fashion. And so now creditors' claims kind of pop up somewhat willy-nilly, much to the frustration of the heirs, who are counting on getting a certain amount of money, and then they find out that there's some other debt. Okay, so that's one problem. Another problem is that when heirs are already in a combative posture, so they may decide that they want to challenge all of these debts. So the administrator could, be perfectly, could be perfectly sure that a debt is in fact valid. It was filed timely. Proof of the debt was provided, and so it's there. But when there's already contention in the probate process, one or more heirs may decide to challenge that debt. And again, what it does is it leads to more time to administrate the estate. It adds cost to the administration of the estate. Okay. And this can be especially difficult when a debt may mean the difference between the heirs getting something and not getting anything at all. So I think a few weeks ago I talked about insolvent estates. Okay, that's an estate where the debts are greater than the assets of the estate. And in such a situation, oftentimes, because the heirs basically think they have nothing to lose, they will do everything they possibly can to delay the proceeding of administration and the eventual closing of probate. Since they're not going to get anything, and in many cases it doesn't really cost them anything, they'll toss in documents disputing this, disputing that, and now it's all got to be dealt with step by step through the probate process. So again, when there's already contention going on, right, this just adds gasoline to the flames when something comes up that one or more of the heirs doesn't like. Now, and by the way, there's lots of things we don't like in this world. That doesn't mean that they're invalid, etc. But what can happen is, a neutral administrator, like a professional fiduciary like me, gets appointed. They go through the decedent's residence. They find documentation. They may find a promissory note. Okay, so some individual was lent the decedent money. The decedent signed a note, and it's a copy of it is there in his records, and so there has to be a determination: is this a valid debt, right? And if it is, all of a sudden the amount that the heirs are getting shrinks, and they're mad. So creditors' claims and debts. This is another problem in an intestate succession. It can be a problem in a succession where there's a will or a trust as well. But in the case of a trust, it doesn't have to go through court. It can be privately worked out. In the case of when there's a will, that will is going to make for a more orderly probate process, and so it's less likely that something will sort of crop up, at the last minute. Okay, next, mismanagement or misappropriation of assets. So, and I'm not talking about just allegations of mishandling and misappropriation. There could be actual mishandling and misappropriation. Okay, but what we're talking about here is a situation, and this often happens when one heir, or maybe just some of the heirs, have access to the assets of the decedent, and they may take it upon themselves to take some or all of those assets. Okay, and then the heirs that don't have access to them, they may know about them. And so when the administration actually starts and an inventory is submitted to the court and they don't see certain things on that inventory, they start wondering, well, what happened to X, Y, and Z? And this adds further, this is a further area of dissension among the heirs, right? So I'm handling a probate right now where the heir of the decedent had essentially control over the assets. Actually, his wife was made the administrator, and she had control over the assets of the estate throughout about a 10-year period. 10-year? Yeah, I think it's about a 10-year period during which a creditor was fighting to establish a valid claim while at the same time proving that a will was fraudulent. Okay, by the time that whole process was settled, and in fact the creditor's claim was upheld by the probate court, and the will that had been submitted to probate had been proven to be a fraud, the only remaining asset was a house. Okay, now let's be honest. The person had to have had a bank account somewhere. The person worked his whole life. There probably were some retirement accounts. Okay, all of those assets disappeared. And because the whole process took so long, there was essentially the time to even get records on any of this had long since passed. So there was no way of knowing in reality what other assets might have been there. Okay. And so in the end, the creditor is on a certain level going to be defrauded by the heirs, or by the heir and his wife, who wrongly had control of the assets for so many years. So this was not a case of a claim or allegations of misappropriation. almost for sure this is an actual misappropriation of assets. But since nothing can be proved in court, it's just too bad for the creditor. Now, in other cases, and I mentioned this example a little while ago. So, in the case of the surviving spouse and the stepchildren, so the stepchildren are claiming that that their stepmother stole certain property from the estate already. Even though at least some of it is sitting in the backyard of the house, right? So in this case, it looks like these are allegations, but there doesn't appear to be, it doesn't appear to be an actual case of misappropriation. Now, maybe it is. Maybe there are assets that the second wife did misappropriate, but if she and her husband had a joint bank account, so she's permitted access to that account and to use those funds, that would not be misappropriation. The stepchildren, though, may feel that it is because the father told them, when I die, you're going to get X, Y, and Z, blah 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 blah, right? But since there's no will, there's nothing in writing. So who knows what the truth of the matter is, right? So it all comes for the court to sort out. Okay. So you could have another situation where let's say there are two siblings, okay, and one of the siblings had access to the decedent's checking account to help the decedent with paying his bills, right? And so then the decedent dies, and now that money does not belong to the sibling who has access to the account. It is in fact the decedent's money. The fact that he has access to it is immaterial in terms of determining ownership. Okay, so you've heard the old expression, possession is 9/10 of the law. That's actually an incorrect expression of it. It's possessions are 9/10 of the law, meaning 9/10 of the law deals with property. So the fact that this maybe it's a child of the decedent has access to the account has no bearing at all on to whom that money would be distributed as a result of the administration of the decedent's estate. Okay. However, the fact that one child has access to the account and the other doesn't, oftentimes that alone will lead to allegations of mismanagement, misappropriation, etc. Okay. And this only complicates the whole situation. Okay. So when there's a will or a trust, right, it's already understood who's going to be handling the administration when the person dies. Okay. It's understood who's going to have access. Okay. And so things can happen much more smoothly, more coherently, and there can be greater confidence that things are being handled appropriately. Okay. And again, this is true of all these issues. Whenever there's a dispute, it takes more time to resolve, oftentimes takes more legal fees to get them resolved. Okay. And so that's the downside, in all of this. Okay, let's take another break. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. Okay, so this is Trust and Estates Weekly, and I'm your host, Kevin Bemmel. We're talking about contested intestate successions, and I've talked about several points of shall we say friction, dispute, drawn out fights between people, determining the heirs, figuring out who's going to be appointed to administrate the estate, dealing with creditor claims and debts, and both allegations and actual mismanagement and misappropriation of assets. Okay, all of these come into play. Okay, next is excluded or undisclosed assets. Okay, now this kind of ties into the previous one, mismanaged or misappropriated assets, but there, disagreements can arise over whether certain assets should be a part of the estate. So let's take that bank account where it's somebody dies, one of their children has access to the account. It appears that was the case in order to just help their parent out, right? But now the parent is dead, there's no will, there's no trust, and the child with access to the account is saying, well, mom said that once I died this money was mine, so I took it, right? And so now there's a fight over whether in fact this asset should be excluded from the estate, right? Now the other child may say, what's the proof of that? It's just your word, and this is mom's money, and so it has to be included in the probate. And off you go to the races, as they say. And by the way, this can happen in a number of areas. It can happen with real estate. It can happen with a business or a business interest. You could have a situation where one child is working in the business and the other isn't. There's no will, there's no estate plan, trust, whatever. And so the child working in the business, and by the way, he may just be assuming this as a matter of good faith, that when his parent dies, he's going to take over and own the business, right? He's the one that's been working on it for however many years, right? So why shouldn't he assume that the business is going to become his? Okay. So, and of course, the other child is looking at it and saying, wait a minute, this business is worth whatever the number is, $500,000, $1 million, $100 million. Why do you get this whole thing? Hey, you chose to work in the business. I chose to go, be out on my own and all of that. And so now you've got, should the business be included? Should it not be included? Okay. And now you've got a court fight. And of course, the larger the asset, the more incentive there is for the heirs to dispute it, right? And and typically, the more money will be spent with lawyers, etc., working these things out. Okay. And I'm trying to think, do I have an example of this? So I've got a case where uh, uh, the decedent was not married at the time he died, but he did have a long-standing girlfriend. When I say long-standing, I think about 20 years. Okay, and the girlfriend lived in a house he owned. Okay, and the girlfriend's daughter essentially decided that the house essentially belongs to her mother because she's lived there so long, right? And so she wanted it excluded from the probate. Now you may say, well, that's crazy. Whoever is on the title to the house, that's who owns it. Well, yes, that's true. Okay. But that doesn't prevent someone from disputing something and making claims. Well, he meant to transfer the house to her. He just never did it. Blah, 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 blah. Right. All has to be worked out in probate. And as crazy as that sounds, how could someone ever think they could get ownership of a property in somebody else's name? It means nothing in probate. people will make the most outrageous claims merely because they think they can get away with it. Okay. And oftentimes, especially there are lawyers who will take these cases, and the idea behind it is to essentially extort money from the estate, okay, or extort some kind of um, something of value from the estate. It may not necessarily be money. In the case of this house, essentially, um, although we were planning on doing this anyway, we made a formal agreement for the mother to live in the house until she died. Okay. And they wanted a whole bunch of other stuff. And like with other cases I've been in, I said, nope, spent $100,000 fighting it, not 2 cents, in extortion money, because I do consider these things extortion. If there's not a valid claim, and a valid claim means there's a valid will, there's a trust, or some other evidence that will stand up in court, that is not a valid claim. Okay. And it's my perspective anyway, that it only makes things worse to give in to these kind of spurious claims, because it's not like they stay private. Inevitably, it seems they get out, and now the next person is there with their spurious claim against the assets of the estate. Okay. And so this is another reason why having a will or a trust, or both in many cases, is so important, because that will delineate who gets what. Okay. And it will, and by the way, it will oftentimes also say who absolutely will not get anything, right? So I was watching a movie last night, and in the movie, a woman's mother dies, and so she and her daughter go to a small town where the memorial service is being held, and I'm not exactly sure who the character is. I'm not sure if it's the woman's ex-husband or something. Anyway, he shows up, and he threatens the lawyer, who's representing the executor of the estate, saying, I'm going to get money out of this estate, right? That baldly. Now, for people, for watching the movie, it's a very dramatic moment and all of that. Had I seen that, several years ago, I would have gone, oh, come on. Now, having been in this business for many years, it's like, yeah, I get it. He's thinking he'll extort money from the estate, right? That's just how, unfortunately, some people think. Okay. And then the final thing I want to talk about is, and this kind of sums up in the end what this is all about, and that is family disputes that lead to legal challenges within the context of the administration of the estate. Every dispute, jealousy, wound seems like a probate is especially an intestate probate, is an opportunity for that to be fought, and fought bitterly. So if there were any senses of favoritism between siblings, or there was one sibling took care of the parent in the last year or several years before he died, and the other one didn't, if there was a child who was estranged from the parent, but nonetheless remains a legal heir, okay, all of these things come out in a probate. And when there's money on the table, it really many times brings out the worst in people. And I often hesitate to say to someone, we're going to treat you like family, because I think we all know oftentimes family members treat each other much worse than they would, a stranger or a friend. But all of these come out, and it seems like they all have to be, not worked through, because in my experience, rarely is any kind of resolution to these issues reached, but they all need to be dealt with in the context of administrating the estate. And I've mentioned some of these disputes along the way. A situation where one child was working in the family business and the other was not, and that the child working in the business feels that gives him a greater interest in the business. Okay, you have a situation where a child was the caregiver of the person for the last several years of his life. So I had a situation. I actually withdrew from it. It just became uh, way too hostile. But it was a situation where a son and daughter had looked after their mother during the last, I think, 2 or 3 years of her life. And then along comes the third child and claims that he has precedent to the assets because he's got a trust that his in which his father was the beneficiary and the trustee. Now the father is dead, so now all the property is his. He proceeds to evict his brother and sister from the house, okay, making them homeless because they spent their time taking care of the decedent for the last couple of years, right? And now the whole thing ends up in court. And inexplicably, the judge took the attitude, well, I'm going to declare this trust valid, even though there were very serious potential flaws in the trust. And the whole way that it came about was very strange, since at the time the trust was created, the decedent's doctors were already diagnosing what looked like dementia and at least diminished capacity. Pages were missing from the trust. The notary public who supposedly I'm sorry, not the notary public, the attorney who supposedly drew up the trust could not be found. Okay. So there's all these irregularities, and yet the judge took the attitude of, well, it's valid. That's it. And by the way, that was one of the reasons why I withdrew, because a judge who would act so precipitously and callously toward other potential heirs is not a judge who's going to oversee an administration in an appropriate way. And what that means for me as a professional fiduciary is I could find myself in a situation where I'm being held responsible for doing something wrong, even though I haven't, and the judge is not going to care, or worse, the judge is going to go along with the allegations of misconduct on my part. So again, all of these family disputes come to the fore. People are angry, they're upset. They may actually be grieving the loss of their loved one, but that doesn't seem to get in the way of fighting over the money. Okay. And so, for all of these reasons, avoid an intestate succession. Absolutely. Do your estate plan. That is really the solution. Do an estate plan. Even if you don't have a lot of property, at least do a simple will. Okay. It doesn't take that long. It's not that expensive. Okay. There are lots of attorneys out there who will help you at a nominal fee. Okay. And if there is any complexity to your situation, they can at least let you know, so you can choose whether to handle it up front. Or look, in the end, I have seen situations where somebody died intestate on purpose because they so disliked their children, and they felt their children had treated them so badly while they were alive, that they basically plan to set their children at each other's throats. And that's very unfortunate. It's unfortunate that a parent would feel that way. It's unfortunate that children would get to that situation, and it just makes so many lives more difficult. But this is the nature of human endeavor, and you see it all in probate. So I thank you very much for joining me today, especially my live viewers. Tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. And on Wednesday at 10 a.m. Pacific time is my show, People Making Money. Okay. And then on Thursday at 5 p.m. Pacific time, on Thursday at 5 p.m. Pacific time is my show, Jiggers's Place. That's every other Thursday. And that's when we sit back and have a cocktail and talk about all the non-financial aspects of life. So I hope you'll join me later in the week. I wish you a wonderful rest of the day. And signing off as I always do, Marie, darling, you are my belle. Courage at all